Out in time for lunch. It was just, it was actually most of what we expected as far as the motions in limine. I think they're good rulings. Any of that evidence would be impeachment evidence or rebuttal evidence and not, in our case in chief. I'm very happy that the court has given both sides the indication that they need to be cautious in how they present the case and that they do it starting with voir dire selection and opening statements. So the idea of actually trying this case in the 6 or 7 minutes that happened that night, which is what I mentioned to the judge, is what we've been arguing for all along. I refuse, however, to not be ready for impeachment and rebuttal evidence if it becomes necessary. So that's why most of what came out last week came out. As you know, if we don't disclose it, it doesn't get used. And we have to disclose it. It's been disclosed. Now it's available if the state goes places that they shouldn't go, or at least that make it relevant for the impeachment. So we're ready and looking forward to getting the case tried.
So I understand this correctly about the IT director. Tell me if this is the right scenario that I gather. The IT director that works for the Duval County State Attorney's Office went to a lawyer and said he believed prosecutor Bernie De La Redondo was withholding evidence from you. That lawyer called you to tell you that.
That's absolutely correct.
What happened after that?
That's absolutely correct. And we found out they knew information that nobody else would know about what they didn't give us. The picture of the gun in the hand, for example, had not been given to us, but that was created back in late January within the state attorney's office. That inquiry, if in fact it continues, and it certainly should, could lead to some very dire consequences for those who made presentations to the judge that are not accurate.
What consequences? What consequences?
I
mean, would it affect the trial, or could it be
we got that part of that is up to the judge. I don't want to presume what she's going to do, but I know what I would do if I said something to the judge that turned out to be completely untrue by indisputable evidence. I'd probably talk to Mr. Schaefer back there.
You referred to 2 videos of Trayvon Martin perhaps refereeing a fight and also the beating up of a homeless man. Can you explain that?
There are videos that are on Discovery. They've been disclosed. I'm not sure where they are, but there's a video that he took about witnesses. But just look at the Discovery. I don't want to give you my interpretation of the evidence. I'd rather you just look at it. But they're in Discovery.
So the Martin family, their attorneys say that all of this stuff is inadmissible and that it was intended just to, pollute the jury pool or sway public opinion. What's your response to that? I said that numerous times.
The public opinion was swayed by a false presentation of this case way from the beginning. The defense had nothing to do with that, and actually the state didn't have much to do with it. But the Martin family, through their handlers, presented a picture of who Trayvon was and who George was that is wholly inaccurate. And this evidence just sort of shows that. Again, I don't have the luxury as a criminal defense attorney to look at this and say, I'm just going to ignore this and never, ever use it under any circumstances. You wouldn't want me to do that if I was representing you, and I will not do it representing George. If it becomes relevant on the way the state handles their case, it's going to get in front of a jury. If the state handles their case the way they're supposed to, it probably won't need to get in front of a jury. But it's discovery at this point.
So Mark, none of the evidentiary stuff rulings today will affect how you go about presenting your case to defend George?
No, I'm very happy with the judge's rulings. We were hoping that we would have some limitations on people commenting upon information that is not yet relevant. So the idea that the state has to be careful how they present their case, and certainly we're going to be careful how we present ours, is exactly what we were hoping for.
Mark, to be clear, so as of today, you still have not received the information that Attorney White was testifying to. Is that correct?
We have received, no, from the state, no. We have, now that we have that information, been able to drill and find some of it ourselves. My frustration at this point is we don't know what we don't know. We don't know what they still haven't given us, and it's just in line with all of my motions to compel and for specific discovery that I've had going throughout this entire case.
So how do you mean you'd be able to drill and find some of it? What are you talking about?
Well, if you look at data, it's not just pictures or pages, it's all binary data. You have to look into it and see what you can find using certain tools. Now that we know the tools that they've been using, I've been looking at some of those tools and finding some. I just don't know what else is there.
Did they give you the binary data?
The IT guy that attorney Blake spoke of has been since, as of today, been put on administrative leave. What would you comment on that?
I don't, are you saying that that's true?
Yes.
Well, that's up to him and them, and I would refer to a couple of statutes that exist out there to protect people who blow whistles on other people. So I'm sure that they're looking into those avenues as well, and there would probably be protection within that confine.
Did they give you the binary data that you've been drilling down into?
We got that in March, I think, after we asked for it for a couple of months,
So
yes.
what the attorney told you is how to interpret that or how to see what was there?
No, they had done specific reports that generated pictures that they had not previously disclosed to us. That's how we knew that they knew what they were talking about.
You were talking, you said, you started off saying we are ready and looking forward to getting ready for this trial.
Well,
You said that you've been saying, I'm sorry,
as-
you've been saying for weeks and months kind of that you're not ready for this trial, you want
Well,
more time. Could you talk about that? Because when you say
yes.
that,
And I might have misspoke. We will have a lot more work to do than we can get accomplished between now and June 10th. But what I sort of meant to say was that if this judge tells us we're trying this case on June 10th, and I believe she has, then we're trying the case on June 10th. And we will present everything that we can get ready to present by June 10th.
What was the reason you wanted to, since you even admitted you can't recreate the conditions that night, raining, or dark, what did you hope to gain by having the jurors, take a van ride over? What was the purpose?
Jury views are used often, not in every case, but when the circumstances suggest it, I think it's quite appropriate. Can we get them there on February 26th? No. Can we get them there when it's dark? Yes. Can we get them there when it's raining? Probably not. But if we give them a feel for how it's going to be viewed, great. But look, I think the judge has already denied that motion, so I'm now bound by and will respect her decision unless she revisits it.
I know, but I just, what did you hope to get? What did you think the jury would be?
Only what I suggested to the judge. It is limited in time, particularly it's limited in geography, so that it's easy for the jury to get a feel what it looks like to walk down there at night, what it feels like to walk down with the darkness at night, where the people were. Even though we can't point out particular witnesses, we can back in the courtroom when we can say, okay, when the van went to the end of this T intersection, that's where the witness was. So they can get a feel for that and then go out and make it three-dimensional for them. But there are alternatives, and we'll look into them. I think we'll be able to.
Mark, when it comes to the evidence you think the state withheld, they mentioned pictures of drugs, pictures of a gun, also a picture of an underage girl. What was that about, and why haven't you released that in reciprocal discovery? Or have you received it?
We have vetted through that discovery, and what was released in the reciprocal discovery was much less than what we got. So we did filter it to a certain extent as to what is appropriate. And I would tell you that a 17-year-old having a picture of a 17-year-old girl or 15-year-old girl, I don't know, I don't think there is even a questionable relevancy to that in this case. The other evidence, pot, guns, whatnot, is arguably relevant.
The text messages, though, from that day on February 26th, I didn't see those. I saw you reference them in the motion, but I didn't see those released. It shows an argument. Where is that?
We redacted those as well, but the state has those, and they're available through the state unless they decide further to redact them.
But you haven't released them in reciprocal. Does that mean you're not going to rely on that?
No. Let's remember that we released the unredacted to the state. They have those now.
You gave us the exact.
That's correct.
Mark, how is George? Can we come today?
Again, he doesn't come to many of the hearings. More my decision, with his concurrence. There is obviously a security concern whenever he travels, and I didn't feel the need to have him here. The last one he was at because the state requested it, if you remember. So we decided to have him there for that.
The photos of the underage girl sexually explicit?
I'm really not going to get into it's just, I decided not to release it in part of reciprocal discovery. I'm not going to comment on it now. I think that would just be counterintuitive. Thanks very much for the time.
talking about text messages with the judge. She says you're going to have trouble with hearsay, you're going to have trouble with authentication.
Authentication?
And you said, I'm working on it, I got subpoenas out. What specific text do you think you'll be able to put on the jury?
I've been the one thing I've been trying to be very good about is not commenting on specific pieces of evidence. There's certainly evidence out there that we've now released in reciprocal discovery, and those text messages relate to issues that I think are going to be relevant, be they pot use, gun, violence, fighting, whatever. And I'm hopeful that we'll be able to present what I know we need to as far as an evidentiary foundation to get it in. And we'll see. That's what a jury trial is for, and that's what a judge is for, to make those decisions.
The judge said no to the THC levels at this point, correct?
I think she said you can't mention it in openings, and we would have to tie it together. That evidence, I think, is going to be particularly relevant once we start showing the expert opinions regarding matters of what effect and behavioral effect you would have under pot or marijuana usage.
What is your reaction to the equal justice, civil rights case? That's what Benjamin Trump puts it. This is a civil rights, equal justice issue.
I'm really not sure that I know what he means. This is a criminal case where my guy acted in self-defense. If he's suggesting that Sanford Police Department acted a certain way inappropriately towards Trayvon Martin because he was black, I disagree with that, having now had an opportunity to review all of the work that they did. If he is suggesting that this is some benchmark for how blacks will be treated in the system, I think that he's going to find that this state is going to do a pretty good job of protecting what happened to Trayvon and why it happened. My concern is that we also protect Georgia's right to a fair trial and not just focus on the victim's right. They have co-equal obligations or co-equal rights to be treated fairly in this system. And I have no doubt that they will.
Just so I'm clear, did the judge, remember the way the judge ruled with the law enforcement officers and the input on the defense witness, what was the ruling about whether you could call them and talk about what they did?
I don't know that she made a final ruling. I think that was something where we need to be careful in opening, but it becomes relevant. Because again, remember that most of the information, they put on their case first, and then we respond. And what our response has got to be related to and relevant to what they put on. We may have other evidence that we consider to be of its own independent relevance, and we'll address that. But a lot of it is what they presented. If they stay to the 5 minutes of what happened between these two men that night, and don't go places where I don't think they should, then we don't have to either. That's the whole point. And so you get ready for whatever battles they may throw at you with the hope that most of your weapons stay in your quiver. That's all. Thanks, guys.